Good afternoon and welcome to our webinar where we'll be talking about employee safety, leave of absences, and managing remote workers in the COVID era. And this is a very fast-paced presentation today. I encourage you to submit your questions at the Q&A at the bottom of the page, and we'll get to as many of those as we can. If we wind up 30 minutes just talking amongst us on screen, then we will stick around and answer questions afterward. And for those of you who can stick around, great. If you have to leave, we do understand. Today, we have 4 presenters. And I'm going to give you brief introductions. If you need to see some more information, you can either check the Department of Public Safety's website, or you can go to our website, rmwbh.com. We have Greg Gotkin. Greg is the head of our litigation section, and today he's in Austin, Texas. And Greg advises folks on areas of risk management, and he also acts as outside general counsel for corporations. Next up, we have Clayton Hearn. Clayton has more board certifications and degrees than rectal thermometers, and they are employment and labor law, residential real estate law, and property owner association law. Last but not least, we have Justin Markell. Justin is the head of our corporate section, and he's also board certified in labor and employment law and helps folks with their employment manuals and things of that kind to keep them out of trouble. Standard disclaimer for this, as all other RMWBH webinars, everything we're going to talk to you about was true to the best of our abilities as of 1:59 p.m. And it's quite possible that sometime later today, the governor or the CDC or somebody else will change things. If that happens, we'll be sure to get out some information to you by LinkedIn or our blog or somewhere. So make sure you consult with an attorney. The advice we give today is general advice, but it should be sound advice for you to use. We don't have PowerPoints for today because today we're going to do just rapid questions between me and the panelists. So without further ado, let's move on. And the first thing I have is for Greg. I'm sorry, for Clayton, just making you all on edge. Clayton, a lot of the questions that I get on a daily basis have to do with employees returning to work. Some want to come back, some don't want to come back. Those that want to come back, do we have to be worried about them being sick? How do we make sure that they're not? How do we make sure that they're healthy? What's the common advice and issues that you're being presented with on that topic?
The common advice I have, a lot of my employers like to have fallen into kind of winging it and assuming that everybody watches CNN or follows the CDC guidelines and might treat the workplace like they would treat a restaurant or a curbside pickup and just merely wear a mask. What I suggest is going a step beyond that, and that is to implement a written health and safety plan that kind of has the processes in there. And one of the key parts of that health and safety plan needs to be to put one person in charge of administering, monitoring, and enforcing it. So this safety plan would have as much detail as cleaning and hygiene procedures, when to wear a mask, when you don't have to wear a mask, but also specific symptoms and health screening issues.
All right, but let's go a bit more specific.
Okay.
I'm an employee and I just don't feel comfortable coming back to work, but you want me at my desk. What do we do?
Well, and I don't want to step on Justin Markell's main topic, and that is when you have to pay people and when you don't. But if I'm taking your premise, you don't want to come to work, I like to always stress, and Justin can go into the exceptions for this. Texas is an employment at will state. You can require of your employees to follow certain protocols. So if you're just nervous and scared and don't want to come to work, the employer doesn't have a legal obligation to keep you employed or to accommodate that request.
All right, well, what if I am healthy enough to come back to work, but because of family situation, I can't come back to work? Is it the same answer?
No, as most lawyers start every sentence with, it depends. if you have a family situation, it depends on what that family situation is. You may be entitled to expanded family medical leave, and that applies, as Justin will point out, to certain employers, and it's expanded family medical leave beyond what the legislature had before. So
Right.
if you're taking care of a kid who's, school's closed down, or somebody who has symptoms, that could change things.
All right. And what about protocol for entry into the workplace? Are you going to give people a checklist? You're going to check their temperature? What are you going to do?
Actually, yes. I was going to suggest, until this morning, I was going to kind of run down a checklist kind of from CDC guidelines, but I was lucky enough to drop my son off at school today. And as a requirement for dropping him off school, I have to go through an app and actually answer health screening questions and submit his actual temperature before I can drop him off. And I think employers, they don't necessarily have to create an app, but they can use that same kind of checklist.
So you're willing to provide that checklist to clients and friends of the firm as a suggestion for helping to keep their workplace healthy.
Right. And to some extent, it might need to be altered or catered to a specific type of workplace, if it's industrial or office or retail. But we do have those kind of screening checklists that we can provide.
All right, let's jump over to Justin real quick. Justin, in terms of the obligations to pay folks or not pay folks based upon their absence from work, I understand that there's different levels of numbers of employee that make a substantial difference. Why don't you explain some of those?
Sure, sure. So earlier this year, Congress passed the Families First Coronavirus Response Act, which imposes new paid sick leave obligations on employers, but only employers who have fewer than 500 employees. Now, there are some exceptions to that statute. One, I guess the main one is a small business exemption. And that just applies to employers with under 50, that's 50, employees. But important to note, though, for that exception, it really only applies to certain requests for leave under the law. It only applies if the employee is asking for leave to take care of kids whose schools are closed or whose daycare is unavailable due to COVID reasons.
All right, so let me stop you there real quick, because I want to make sure I understand this. If you have an employment situation with under 50 people, and I can't come back to work because my child's school is not an in-person school, there's some obligation to pay those folks, but are they required to work from home at the same time?
Well, okay, so the leave obligation kicks in if the employee is unable to work or telework because the employee has to take care of kids whose school is closed for COVID reasons. So if the employee can telework, like if the employee can just work from home, then the leave obligation wouldn't kick in.
All right, so if they've been working for 2 or 3 or 4 or 5 months already from home, and then they say, well, I can't work anymore because I have a child at home, there's no obligation to pay those folks because they can work from home. They've established that they can work from home, right?
Yeah, the DOL is a little squirrely about that. There is an FAQ on the DOL's website, and it basically poses this question, like, what if this employee has been successfully teleworking for several months, and then now that school is going to be in session, the employee requests leave to take care of those children because the school isn't physically open. The DOL does say that employers can ask about changed circumstances, like how come this is different, but basically to tread lightly.
Okay.
You don't want to give the impression that you're trying to interfere with an employee's right to leave.
All right. Now, what's the difference between a situation where it's under 50 employees versus under 15 employees?
Yeah, so the Families First Coronavirus Response Act, so as a general proposition, it applies to all employers under 500 employees. There is this exception where an employer under 50, might be able to deny a request for leave if the reason is taking care of kids whose school is closed. But that's so employers under 50 might be able to get out of some leave obligations. If you have an employer under 15 employees, that's 1-5, then we would really be looking at other statutes at play. For example, if an employee has a really bad case of COVID and has already exhausted any leave entitlements under the Families First Coronavirus Response Act, you wouldn't necessarily have to look at the Americans with Disabilities Act if you're under 15.
All right, so ADA does not affect employers that have less than 15 employees.
Correct.
Yes, the legal test is 15 employees within 20 calendar weeks of the current or preceding year.
Blah,
But,
blah,
yeah.
blah, blah, blah.
Yeah.
Okay, all right. So let's get to the employer who has more than 15 and less than 50. They can't use the small employer exemption, right?
They can
Sorry,
if
say
they're
that
less
one.
than 50.
Right, right.
If-
And
They
so
can.
you have those in that number frame. How does ADA play in addition to all these other COVID acts?
Right, so the ADA might come into play if you have an employee with a really bad case of COVID. If the employee has a really bad case of COVID and it's not really temporary in nature, but it is debilitating and it substantially impairs that employee's ability to perform some kind of daily life function, then that could be considered a disability. And so under the ADA, additional unpaid leave could be required as a reasonable accommodation for that employee.
Okay, all right. Now, let's move on to some working remote issues. And then I'm going to come back to some specific questions for all of y'all. Greg,
Yes.
some of the problems that we have seen from our clients that have been calling in is that employees are now in possession of confidential information at home, and also that they have equipment that they're using at home. And finally, the other question I'd like you to address is people are saying that, yeah, they say they can telework, but they just don't seem to get as much done as when they were in the office. So what's your advice for those folks?
Well, first of all, in terms of the issues related to confidential and proprietary information, and this also plays into the usage of electronics such as computers and cell phones, et cetera. What we're seeing a lot of situations where the employees are using their own computers. They're not necessarily computers that have been provided by the employer, that often lack the security aspects that the employer equipment has. That in of itself can lead to a lot of issues. And that's the electronic part. Then we have just the leaving stuff around where anyone can see part. I kind of give the advice of, if you wouldn't leave it around your conference table for other people to see, don't leave it around your kitchen table or wherever your employee may be working. It needs to be protected and kept safe.
All right.
In terms of
And-
productivity,
Yes.
you know, there's a legal answer and there's a practical answer, and they both operate in the real world. The legal answer is, when you're working remotely, an employer can require that the same level of expectations in terms of productivity be met. The real world aspect of this is we all have employees right now working remotely, including our own firm. And they're, I believe, doing their best. Obviously, you have some people that will always take advantage no matter what. Those same people will take advantage even in-house. But they are trying to get the work done while also taking care of kids. You may have a sick spouse, parent issues, what have you. What is most important, and this is really something that Justin and Clayton can touch on, is the issues related to potential overtime and what employees, when they're clocking in, when they're not clocking in. And it's critical to make sure that even though you don't have the time clock like you may have in the office, not the one on the wall, but we all know when they're there and they're not there, the sign-in procedures, sign-out procedures, et cetera, that those are still being followed. And the key is really to set the proper expectations, I think, and that is talking to your employees and saying, look, we understand that this is not a normal time. It's very unusual. And everything is getting thrown at us at once. The school issues change daily. When you can go back to work, when you can't go back to work, what is a critical employee versus non-critical employee, all that. I think setting forth real expectations, having proper communication with your employees, but also with the understanding that this is still work. You treat your work at home just like you treat if you're working in the office. And that includes the confidentiality aspects that we mentioned earlier.
What about company equipment that they've taken home, and all of a sudden their child pours a whole jug of Kool-Aid into the computer? Whose responsibility is it for the company equipment when it is in a remote location?
Well, that again is probably a good answer, a question that Justin or Clayton can answer as it relates to policy manuals and policies and procedures related to company-owned equipment. Essentially, if you're going to have employees take equipment home, there needs to be some rules and set out that is signed off by the employee, at least in the manual, that discusses who's responsible. And also addresses these issues we mentioned earlier about confidentiality and making sure that things aren't left out on the computer, et cetera. You don't want your teenager getting on and checking the Facebook page on one window while you have proprietary information from a client on another. And it is absolutely needs to be protected and kept separate and apart from personal surfing on the internet, et cetera.
All right, let's go to a couple of the questions that we've received. First question is, I'm going to address this to Clayton and Justin. Employee is at their desk and they hear that their spouse has now tested positive for COVID. What do we do?
That would fall under the CDC guidelines for quarantine. And there's a distinction between quarantine and isolation. I actually had to look it up because I thought the two were the same. Quarantine is when a person is asked to stay away from people. They're kind of homebound on home confinement, yet they're still around their family members. And then isolation is when you actually try to isolate within your home, even from your family members. So the spouse gets COVID, like in your example, the employee should be sent home and be quarantined for exactly 14 days after their spouse goes into isolation. And that's if the spouse can isolate from them. If the employee is a caretaker and cannot distance from that person who's positive, they need to go not 14 days from the beginning of the isolation, but 14 days from the end of the isolation.
All right, and are we going to require as an employer a negative test before that employee is permitted to come back to work, or just the 14 days?
I would require a negative test because the 14 days and how much they've been in contact with the other person, it's kind of on the honor system. I think to protect your other employees, my suggestion would be to require a positive test. I mean, a negative test.
A test that shows they have no COVID.
Correct.
All right. And Justin, there's all kinds of tests out there. Do you, as an employer, care what kind of tests they get to show that negative result?
Yes. I think rapid tests are generally okay. I would advise against antibody tests, only because those kinds of tests only show whether you had it in the past or not. It doesn't really say whether or not you currently have it, or whether you're within the time period of being contagious.
All right. Now, and any one of you who wants to answer this is fine with me. And by the way, these are not prepared questions back and forth. I'm trying to just get these guys on the spot, just like if you were to call them on the phone. They can start with "it depends," but they better darn well give you some advice before they hang up the phone on you, okay? And my question really goes to the issue of socialization. We have some people who just cannot stay at home. And so they're going out every night and having dinner at a restaurant and meeting 20 of their friends, although maybe they're not supposed to. And you become aware of that. And they show up to work the next day talking about the big darn party they went to last night. What do we do about that employee? When you start to talk, or I'm going to randomly pick one of you.
I'll just jump in right here. This is an issue that kind of goes beyond your specific example. Like how far does an employer go to regulate out of work conduct? It really kind of depends on how much you want to look at their outside activity to enforce it. If you're going to be on social media every day trying to check your employees' Facebook accounts to see if they're complying with your policy, I guess that's something that you could do. But if you're going to have a policy that if you're going to have a policy that regulates out of work conduct, just be prepared that you're going to have to spend a lot of time trying to enforce it. And if you enforce this to one employee, you better put in the effort to enforce equally across the board, so you don't end up with a discrimination claim.
Well, what if you just hear about it directly from the employee? They're in there at the water cooler talking to 3 of the employees and saying, "Man, it was a hell of a party last night. There were 40 people there. And I couldn't believe none of them were even wearing a mask."
Let me jump in here, Mark, because I take a little bit more of a hardline approach to Justin, and that's kind of our basic philosophies. Often we come to the same answer, but I believe that employer, because we are an at-will state, has the ability to regulate some out-of-work behavior. If that out-of-work behavior endangers your employees, you can insist that that person not return to work for 14 days if they're engaging in risky behavior. I mean, we've had entire universities in our country closed down over the exact same thing.
All right, so we are going to send them home. Do they now, if they can't telework, do they get paid?
No, they don't get paid because they don't fall under Justin's specialty, the FFCRA. I'm sorry, we're not supposed to use initials on this call, but seriously, no, they're not necessarily entitled to pay. They can use the PTO or invoke whatever leave policy you have at the employer's company.
All right, now let's talk about employment policies. Isn't the horse already out of the barn? Is it too late to put policies in place?
It's advisable and doable to have reached out and had your counsel working on a policy prior to today, but better late than never is kind of my motto. I would rather see you put a policy in place now because you might have issues from today going forward. So I would definitely put a policy in place.
All right, so policies that we'd be looking for at this point in time deal with what specific issues so that folks can look at their manuals and say, this is in there or this is not in there?
Well, I can say for sure that you probably don't have a disease transmission provision in your employee manual if it was written pre-COVID. So what you're going to be looking for is in a health and safety policy, like we were alluding to, very specific things that relate to the COVID pandemic and probably the next pandemic that could come down the road about symptomology, symptom reporting and screening and so forth.
All right, and this could also have the equipment policies in it as well?
Absolutely. You can have an entire policy that covers health and safety, remote working policy, which would necessarily, or at least I would suggest a remote working policy include the equipment issues that Greg brought up.
All right, so the health and safety policy with illness, does that have to be worded in such a way that you can't, you would say to somebody, hey, you got the flu, you need to go home? Or is it just pandemics?
I mean, it's always been my personal policy and our company policy to send people home if they have the flu. So that was pre-pandemic because you don't want anyone with a contagious illness, or at least an airborne or a touch contagious illness in your workplace.
All right. Now let's go to another employment type situation. Once again, anybody's welcome to answer. Your spouse is in a position where they have high risk of exposure. Let's say they work in the jail, or they work in a situation where they're in a restaurant handling the drive-up stuff, handing stuff to people all day long. And you're thinking, well, hell, that's probably the worst potential risk for us of spreading the disease inside our operation. Can we merely say to them, we don't want to assume that risk, you need to work from home?
I think the answer is yes, only because as a general matter, employers have the discretion to either require an employee to work at the office or at home. So long as it's a position where the employee can remote in and work from home, then I think that's a reasonable ask from the employer.
All right. What about jobs that can't be done from home? And just an easy one is janitorial service, okay? You can't clean the office if you don't go to the office. And that person falls into one of these CARES Act exclusions or something like that. What's the situation in terms of obligation and payment?
Yeah, so if the employee is unable to telework because of the job, and the employee falls under a qualifying reason for leave under the Families First Coronavirus Response Act, then the employer would be required to provide up to 2 weeks of paid leave under the paid sick leave component of the statute. And if the reason for the leave is taking care of kids whose schools are closed due to COVID, then the employee might be entitled to an additional 10 weeks of leave under the expanded family medical leave side of that statute also.
All right, now how difficult is it for you to evaluate a situation and advise a client as to whether they have to make a payment, should make a payment, or don't have to make a payment?
Yeah, not to be like a lawyer and say it depends, but it kind of does. It depends on what the reason for the leave is. If it's something as simple as taking care of a kid whose school is closed, then in terms of documenting the need for leave, the employee can present a screenshot from the website for the school saying, hey, we're closed.
All right, now let me hit it close the school thing one more time because we only have 2 more minutes and I believe this is important. I have a child and the school is open, but it's at my option that they don't have to go to school. They can do virtual school. CARES Act?
I would say
Yeah,
no.
so yeah,
I'm sorry. Go ahead.
Okay. So the answer is no. Like when we say that the leave entitlement kicks in when the school is closed due to COVID reasons, what that really means, and what the DOL has recently kind of expanded on, was that it basically means that the school is closed to that student. So if you're in a hybrid situation where the kid can only go into school like Mondays and Wednesdays, then the employee might be able to exercise that leave entitlement for Tuesday, Thursday, Friday.
But if the school is open, but an election is made by the parent, they have no rights under the act.
Correct.
That's correct.
And both employment attorneys agree, so something must be wrong, right?
Yeah.
And DOL is?
Department of Labor.
Okay, because I don't like initials.
We both violated the rule.
That's right, that's 1 each. Godkin has not violated a rule yet, and it's 2:30. So I'm going to give each one of you a minute to say a closing comment about just the nugget of information that you want to advise your clients. Justin, why don't you start out?
Sure. When it comes to leave obligations, if an employee asks for leave and you don't know what to do, certainly call your lawyer. These new laws are very complex and they were passed out very quickly, and so they're a lot of times just not intuitive. So when in doubt, call your lawyer. and try to be reasonable with employees. Everybody's going through a really tough time with this pandemic, and if you're not reasonable, then you might end up on the front page of the news. So,
Ugh, you don't want that. All right, Clayton, final thoughts.
I would emphasize flexibility, and it kind of dovetails off of what Justin just said. Your regular leave policy, your regular telecommuting policy is going to have to be modified to keep your workforce retained. So you're going to have to be able to make changes. Also, another area you're going to have to make changes, you're going to have to constantly monitor the CDC guidelines and your local guidelines, because I'm here in Dallas, we could go into a total shutdown where certain employees are not even allowed to leave their home unless they're an essential worker. And whether you're an essential worker or not becomes an issue. It's not as much an issue right now, but it could return to us.
All right, and Greg, final thoughts.
I'm gonna, yeah, kind of reiterate what both Justin and Clayton said, and I think it's the flexibility aspect of all of this. I mean, we're being asked to, in some ways, give hard-line answers. A lot of times, clients need to hear, "This is what you can do," but really, this is what you probably should do as a good employer. I can tell you from just our experience here at the law firm, one of the things that we've learned is really keeping the line of communication open with employees while they're working remotely is critical. Letting them understand what's happening, why certain rules are being implemented, that it's really for their safety and for the safety of their coworkers, and making sure that that line stays open, because unfortunately, this isn't going away tomorrow. Things are changing by the hour, it seems. And we're going to be dealing with this for a while. So the flexibility aspect is absolutely critical. But again, specific questions, reach out to us, reach out to your lawyers that you guys may use. And if you, in that way, you don't get yourself in a pickle, if you can avoid it.
And I'm going to say that when we say reach out to your lawyer, we're not looking at doing a ton of research on these answers. Most of these answers are our best digest of everything that has been put into the blender. And we're going to err on the side of conservative on our office. And so we don't want you to be on the Fox News channel, okay?
Right.
We want you to be in a position where everything you do will not be subject to some really oddball challenge. Well, that ends our time for today. If you have questions that we didn't get to, feel free to email us. They just take a minute or two to answer. You're not going to get any bill, and whether you're a client or not, we want to help you. And so please, please, please reach out, and reach out continually to us or to the attorney of your choice. It's better to do that than to make a critical mistake. If there's other topics that you want to hear about in our future webinars, please send them to me. mmarkell@rmwbh.com, real easy to find on our website or otherwise. And we look forward to chatting with you again. Till then, have a great day.